Hello, everyone. I see people are still joining, and welcome to IC18 ATP Certification and Ethics for the New Era, which is part of the RESNA track. I'll be moderating today's session, and Dan Resnick will be monitoring as well. And you'll be muted during the session. You can put questions and comments into the chat feature throughout the session. And I'll go ahead and turn it over to Julie and Mike, who will introduce themselves and who are your presenters for the session. Thank you.
Thank you. Thank you, Patricia. And thank you, everybody, for joining our session today, ATP Certification and Ethics for the New Era. My name is Julie Piriano. I'm a PT, ATP, and seating and mobility specialist that has practiced in the area of seating and wheeled mobility for the last 38 years. I'm also the Vice President of Clinical Education, Industry Affairs, and Compliance for Quantum Rehab, and am the current chair of the RESNA Professional Standards Board. Mike?
Hi, I'm Mike Seidel. I'm an ATP and a CRTS. I'm currently the Vice President of National Accounts at New Motion. I'm a past chair of the RESNA PSB. I'm a past president of NARTS. I currently serve as one of the NARTS review chairs, and I also currently serve as the president of the Kansas City chapter of the Case Management Society of America. Thank you.
And unfortunately, Dr. Carmen DiGiovine, who's an ATP, SMS, and RET and clinical professor at The Ohio State University, is not going to be able to join us at the start of the session, but hopefully will be able to join us for Q&A at the end. At the end of today's course, I hope that you'll be able to identify 3 goals of certification, that you'll be able to explain the process for filing a complaint, that you'll be able to list at least 5 RESNA standards of practice and how they may be violated, and list 6 critical questions that you should ask yourself when faced with an ethical decision. So what is certification? Professional certification is the voluntary process by which a non-governmental entity, such as RESNA, grants a time-limited recognition and use of a credential to an individual after verifying that he or she has met predetermined and standardized criteria. Why do we have certification? What are its goals? Number 1 is to demonstrate a commitment to professionalism. Number 2 is to validate an individual's qualifications. This is achieved by providing practice-related, knowledge-based requirements against which an individual can be assessed, and is further exemplified by our commitment to continued learning. And number 3, it's in place to uphold industry standards. We do this in order to convey a connotation of trust, belief, and confidence, or good moral character. And it requires further adherence to a code of ethics and a standard of practice. As a RESNA certified assistive technology professional, we are service providers who analyze the needs of individuals with disabilities, assist in the selection of the appropriate equipment or services, and train the consumer on how to use the specific equipment recommended. On December 31st of 2021, there were 4,303 ATP certificates in good standing with RESNA, which is up more than 7% from that same date 5 years ago. To use the ATP designation, a successful applicant must meet specific education and training requirements, fulfill direct in-person work experience requirements, and successfully pass the ATP exam in order to earn the credential, and then continue to meet the education as well as the work experience requirements every 2 years for recertification. For additional information on this or the alternate pathway to ATP, I encourage you to visit the RESNA website at www.resna.org/certification. One of the questions that RESNA gets asked a lot is what constitutes direct in-person work experience. Direct in-person work experience, in my opinion, is pretty simple. It is defined as those services that are provided in person or through a virtual format, as this conference will show you, to consumers and others related to or working with consumers. Now, that may include, but is not limited to, evaluation, assessments, and other direct-to-consumer or student services. It's fitting, adjustment, and readjustment services. It's the implementation and training for consumers and their caregivers, or students and their support personnel. Or it may be product design and development that involves direct consumer participation. For recertification, it may also include a whole host of other important activities that certified assistive technology professionals engage in order to advance the field of AT and the knowledge and skills of those that are involved in it. In addition, every applicant must submit an affirmation of good moral character with both their initial as well as their recertification applications, attesting to the fact that they have not been convicted of, pled guilty or no contest to, been acquitted by reason of mental disease, entered into a diversion in lieu of prosecution, or had any adjudication withheld on a felony charge, or a misdemeanor involving things like theft, fraud, bribery, corruption, perjury, embezzlement, solicitation, dishonesty, physical harm, or substance abuse in any legal jurisdiction, nor have they been subject to adverse civil or administrative judgments for these same misdemeanors, or really any other offense that calls into question the integrity of their judgment or their actions. They must also attest to the fact that they are not currently, nor have they ever been subject to disciplinary action by any professional body or been discharged from employment for any offense that calls into question the integrity of their judgment or actions. Now, a yes on the good moral character affirmation does not automatically preclude someone from obtaining or maintaining their ATP credential, but it does mean that the situation is reviewed. And just as a reminder, RESNA has the authority to audit any application at any time to verify the information on the good moral character affirmation. And lastly, the applicant must confirm that they are in compliance with RESNA's standard of practice and code of ethics. Now, according to Susskind and Susskind in their book, The Future of Professions, How Technology Will Transform the Human and Experts, published in 2015, there are four main components to a profession. One, participants have specialist knowledge. Two, their admission depends on credentials. Three, their activities are regulated. And four, they are bound by a common set of values. The RESNA standards of practice are our common set of values that set forth the fundamental concepts for ethical practice as an ATP. And without them, we really wouldn't have a profession. The standards of practice are a set of 22 rules that govern the actions of an ATP for the provision of all types of assistive technology in all practice settings and across all service delivery models for all ATPs that are designed to promote high ethical standards in a client-centered approach that stresses cooperation, team building, and follow-up, promotes collaboration, and encourages referral to other professionals when appropriate. Violation of one or more of these standards of practice can result in action being taken by the RESNA Professional Standards Board, who oversees the certification program, and as recommended by the Complaints Review Committee. So let's take a look at the standards of practice and see what they say. The first standard says, individuals shall keep paramount the welfare of those served professionally. In other words, do no harm. Number 2 says, individuals shall engage in only those services that are within their scope of competence, their level of education, experience, and training, and shall recognize the limitations imposed by the extent of their personal skills and knowledge in any professional area. This is a hallmark of being a professional in the field, which I'll admit has changed significantly over the last 25 years, where the balance has shifted to include more education, training, and cross-training across an array of AT. Unfortunately, we've also seen ATPs that list their practice specialty area as AAC, computer access, or orthotics and prosthetics, who have signed off on seating and wheel mobility evaluations, indicating that they have performed the direct in-person assessment and believe that that's okay to do so because they're an ATP. If your skilled professional services include seating, positioning, and mobility, then it is your responsibility to, first of all, check the right box, or if you've acquired skills that have not been listed initially when you submitted your application or recertification application, go on the RESNA database and update your information, because that is the public's visibility of your practice areas or specialty areas that you engage in. Number 3 says, in making determinations as to what areas of practice are within their competency, assistive technology practitioners and suppliers shall observe all applicable licensure laws, consider the qualifications for certification or other credentials offered by recognized authorities in the primary profession, which comprise the field of assistive technology, and abide by all relevant standards of practice and ethical principles, including RESNA's Code of Ethics. RESNA has been made aware of wheelchair supplier ATPs who have written all or portions of the seating and wheeled mobility evaluation that is protected by state licensure laws and clinical practice acts, and preclude anyone other than a licensed clinician from performing, documenting, or billing for certain tests and measures that may be used during the physical and functional evaluation. If the supplier is trying to be helpful by recording the findings of the clinician, such as balance, strength, range of motion, etc., this is known as scribing and is not permissible for the supplier ATP to do or the clinician to allow. Number 4 says, individuals shall not willfully misrepresent their credentials, competency, education, training, and experience in both the field of assistive technology and the primary profession in which they are members. Individuals shall disclose their employer and the role they serve in the provision of assistive technology services in all forms of communication, including advertising that refers to their certification in assistive technology. This means in direct communication, such as greeting the consumer, their caregivers, students, and others; in written communication, such as documentation or email signature lines; and in advertising or marketing materials, such as business cards, letterheads, and etc. For instance, as a licensed clinician that worked for a wheelchair supplier as an ATP, it was perfectly acceptable for me to put my license and credential information on my business card and use it in my signature line. But when I greeted the client at the evaluation, I was required to disclose that I worked for ABC Medical and was participating in the evaluation as the supplier of their prescribed equipment. Number 5 says, individuals shall inform consumers or their advocates of any employment affiliations, financial or professional interests that may be perceived as to bias the recommendations. In some cases, individuals shall decline to provide services or supplies where the conflict of interest is such that it may be fairly concluded that such affiliation or interest is likely to impair professional judgments. In other words, even though I am a licensed clinician and am allowed to perform the physical and functional evaluation of a client, I cannot wear two hats in any evaluation and recommendation process for AT, even in my off hours, as it is a conflict of interest if I or my employer benefits from my recommendation. Number 6 says, individuals shall use available resources to meet the consumer's identified needs, including referral to other professionals, practitioners, or sources, which may provide the needed product or service. I think this is pretty well understood, especially when the needs of the consumer are outside your scope of knowledge and skills. And of course, it's the answer everybody's looking for on the ATP exam, E, refer on. But in a more realistic consideration of this standard, if the ATP doesn't have access to necessary resources, such as trial and simulation equipment or evaluation equipment, such as an ultra lightweight manual wheelchair or alternative drive control systems or a pressure mapping system that might be necessary, then they should refer on to a facility, organization, or supplier that does, or invest in those resources. Number 6 says, individuals shall cooperate with members of other professions where appropriate in delivering services to consumers and shall actively participate in the team process when the consumer's needs require such an approach. Interprofessional collaboration is another hallmark of providing AT services and has been linked to better outcomes. So one example of how this standard could be violated is if a non-credentialed colleague is performing the technology assessment with the consumer. As a certified ATP, you cannot sign off on their assessment, even if you review your colleague's work. However, if you're supervising or mentoring them and are present and actively participating, then it would be permissible to co-sign the direct in-person assessment. Now, another example from a supplier perspective is if you receive a request to bid on the provision of a wheelchair for someone you haven't seen. This is known as blind bidding, and it may be considered a violation of this standard if you participate in this activity. Number 8 is the standard that the PSB gets asked about the most. It says, individuals shall offer an appropriate range of assistive technology services, which include assessment, evaluation, trial, stimulation, recommendations, delivery, fitting, training, adjustments, and/or modifications, and promote full participation by the consumer in each phase of service. While it is not required for the ATP to perform all of these services, in a client-centered model for service delivery, it is best practices, regardless of the AT recommendation. In the provision of seating and wheeled mobility, for instance, it may be acceptable for the supplier ATP to delegate some of these functions to another skilled, competent individual. However, the evaluating ATP is ultimately responsible for the tasks and the outcome. Additional information with regard to best practices model of wheelchair service provision can be found in the RESNA Wheelchair Service Provision Guide that is available on the RESNA website in the resources section. Number 9 says, individuals shall verify consumers' needs by using direct assessment or evaluation procedures with the consumer. While emerging technologies and innovation have and will continue to impact the definition of direct assessment, I would say that it's highly unlikely that a questionnaire or a phone interview with a consumer will ever provide sufficient information necessary to make an accurate recommendation for AT. But it may be a place to start. This can give you an idea as to how complex the client is, how complex the intervention may need to be, and how much time to allocate for the encounter or encounters, and what method will be most effective. Direct assessment allows you to consider the physical, functional, and environmental needs of the consumer, and may be accomplished with everybody physically present, by teleconference with video and audio capabilities, or a combination of the two. In January of 2021, the Clinicians Task Force put together a terrific guide for using telehealth when serving clients needing complex rehab technology, which can be found at the Clinicians Task Force website, www.cliniciantaskforce.us. Number 10 says, individuals shall inform consumers about all device options and funding mechanisms available, regardless of finances, in the development of recommendations for assistive technology strategies. The ATP has an obligation to the consumer to use their skilled professional judgment when making equipment recommendations to meet the identified needs of the consumer and not be unduly influenced by what may or may not be considered a covered benefit or paid for by their third-party funding source. Certainly, this is easier said than done, but the ATP must explain why they are or are not making any recommendations, as well as the pros and cons related to the recommendation, so that the consumer can make an informed decision as to how they want to spend their financial resources. Number 11 says, individuals shall consider future and emerging needs when developing intervention strategies and fully inform the consumer of those needs. Now, a crystal ball would certainly make this a lot easier. Absent that, when contemplating an AT recommendation, the ATP must take into account the client's current need, but it is also fundamental for you to understand the consumer's diagnosis, prognosis, and any contributing or comorbid conditions or factors that may affect their future AT needs as well. Aging with a disability is just as important to consider as the consumer's risk for secondary medical complications or anticipated changes with a progressive condition. When, where, and how the AT will be used should also be reviewed, as the recommendation may be appropriate for use in one environmental setting, but may not work well in another. Further, it's important that we keep up with emerging technology and innovation, as this plays an important role in serving our clients, being mindful that we also have a wide array of individuals that we work with that range from technophile to technophobe when it comes to their level of comfort with assistive technology. And one last reminder, overprescription may be just as inappropriate as under prescription or recommendation. Number 12 says, individuals shall provide technology that minimizes consumers' exposure to unreasonable risk. Individuals shall provide adjustments, instructions for use, or necessary modifications that minimize risk. This is the #1 consumer complaint received by the RESNA Professional Standards Board, especially when there is either an actual or a perceived lack of communication and responsiveness to address the problems that they're having with their AT. To minimize this issue and the he said, she said dispute associated with it, document the conversations, any adjustments, modifications, or instructions for use that you've provided, and the next steps that were agreed upon by both parties. This is important for both the client and the next person who works with that client, which might be you. And your memory is never as good as you think. Better to have it written. Number 13 says, individuals shall fully inform consumers or their advocates about all relevant aspects of the final recommendations for the provision of technology, including the financial implications, and shall not guarantee the results of any service or technology. Individuals may, however, make reasonable statements about the recommended intervention. Evidence-based practice and ethics will tell you that it is the ATP's responsibility to identify and articulate the pros and cons of a recommendation, allow the client to make an informed financial decision, and document their decision relative to the AT recommendations that they will proceed with, the recommendations that they may add at a later date, and any AT recommendations that they are not electing to pursue, and why. Number 14 says individuals shall document within the appropriate records the technology evaluation, assessment, recommendations, services or products provided, and preserve confidentiality of those records unless required by law or unless the protection of the welfare of the person or the community requires otherwise. Remember 3 very important things. Don't put any information on social media unless you have explicit permission from the client. If it's not written, it didn't occur. So document what you did, and more importantly, what was discussed and the decisions that were made. And lastly, your clients are not your clients. They are the clients of the company or the facility that you work for. So don't take any part of a client's file with you if you leave your current employer. Number 15 says, individuals shall endeavor through ongoing professional development, including continuing education like ISS, to remain current on assistive technology relevant to their practice, including accessibility, funding, legal or public issues, recommended practices, and emerging technologies. Staying up to date on the technological advances, innovations, and trends in the field of assistive technology is incredibly important to best serve our clients, and there are ample opportunities to do so. But we are all very busy people with a passion for helping one another. So one way that this standard could be violated is by falsifying attendance at a course, like giving the course code to somebody who wasn't actually in attendance, as would receiving the code and submitting education and training that you did not attend on your recertification application. Number 16 says, individuals shall endeavor to institute procedures on an ongoing basis to evaluate, promote, and enhance the quality of service delivered to all consumers. I think we inherently do this in the world of assistive technology service delivery, but we can approach it one of 2 ways. We can assume all is well if our client doesn't contact us and assume, which you know what happens when you assume, or we can actively participate in outcomes measures, verifying the recommendations are meeting the client's needs, and create a closed-loop feedback system where the client is an active participant. Much better way to approach it. Number 17 says individuals shall be truthful and accurate in all public statements concerning their role in the provision of all assistive technology products and services. In other words, don't let your ATP certification lapse. If you are lapsed, you're no longer an ATP in good standing and cannot use the designation. In addition, if any of your information changes, especially if you change employers, practice settings, service delivery models, etc., please update your profile on the RESNA website. You have every capability of logging in and doing so easily. Number 18 says, individuals shall not discriminate in the provision of services or supplies on the basis of impairment, diagnosis, disability, race, national origin, religion, creed, gender, age, or sexual orientation. This seems obvious in all walks of life, and yet it still happens. Well, we have made positive strides forward. We can do more in terms of diversity, equity, inclusion, and access to enabling technologies that make a huge difference in the daily lives of those we serve. Number 19 says individuals shall not charge for services not rendered, nor misrepresent services delivered or products dispensed for reimbursement or any other purpose. This seems obvious, but crazy things happen at the end of the month, and especially at the end of the year when consumers have met their deductible and their out-of-pocket expenses, like delivering a picture of the equipment for the consumer to take possession of with a promise to bring the real thing once it comes in the new year. Remember, if it isn't documented, then you didn't do it. And if you document it, then you better have done it. Number 20 says, individuals shall not engage in fraud, dishonesty, or misrepresentation of any kind or any forms of conduct or criminal activity that adversely reflects on the field of assistive technology or the individual's ability to serve consumers professionally. When there's pressure or motivation to commit acts of fraud or dishonesty and an opportunity to do so, it's followed by a rationalization or justification that it's okay to do whatever, because fill in the blank of whatever it makes you feel okay to commit the fraud triangle. We've fought too long and too hard to keep from getting painted with the broad brush of fraud, waste, and abuse. But we're a young profession, and we need to continue to hold ourselves to a high standard of ethical practice in all endeavors. Number 21 says individuals whose professional services are adversely affected by substance abuse or other health-related conditions shall seek professional advice and, where appropriate, voluntarily withdraw from practice. There are protections under the ADA for substance abuse that have allowed RESNA to suspend ATP's certification for a period of time and under certain conditions, as opposed to revoking the credential for violations. But if this is the case, you are also able to put your certification on hold so that you don't have to meet the work experience requirements in that recertification period. And then when you're ready and able, come right back into it and pick it back up in reinstatement processes. And lastly, number 22 says, individuals shall respect the rights, knowledge, and skills of colleagues and others, accurately representing views, information, ideas, or other tangible and intangible assets, including copyright, patent, trademark, design contributions, and findings. Bottom line, give credit where credit is due in all works. As a RESNA certified ATP, it is your responsibility to abide by the RESNA Code of Ethics and the standards of practice, and to be vigilant in identifying, documenting, and reporting infractions by other ATPs to protect the public and the industry. The RESNA Professional Standards Board has a separate complaint review committee that's responsible for processing and adjudicating complaints submitted against RESNA certificants who may be in violation of the standards of practice or code of ethics. The CRC thoroughly investigates each complaint and conducts monthly meetings via teleconference to discuss and adjudicate each complaint in a timely manner. The formal written complaint can come from anyone with firsthand knowledge of an alleged violation. To file a complaint, the complainant should download, complete, and submit the complaint form to certification at resna.org, along with any supporting documentation that's available that provides evidence of the infraction or infractions. Complaints cannot be anonymous, so that the CRC is able to conduct their investigation during the adjudication process. In fact, when you file a complaint, you grant permission to the CRC and the PSB to share your identity with the evidence submitted with the individual that the complaint is being filed against. The other thing to know about the submission of a complaint is that the CRC may not be able to take action until any legal or administrative proceedings are completed, unless the complaint is not related to the charges. It's vital that certificates and others report any alleged violations, misrepresentations, or misconduct so that the PSB can take the steps necessary to protect the public and the value of certification. And we strongly encourage you to do so. At their monthly meetings, the CRC reviews new complaints, and if it has merit, the certificate that is the subject of the complaint is given an opportunity to respond. Complaints in process are developed, and the CRC tracks complaint evidence, documentation, and status depending on when the complaint is received in adherence with the complaint's policy as well as the violation rating system. Depending on the severity of the complaint, legal counsel may also be sought prior to adjudicating the complaint to verify that the actions taken by the PSB or the CRC are defensible. The decision is communicated to the subject of the complaint, and the complainant is made aware that a decision was rendered. If the defendant does not agree with the decision, then they have an opportunity to appeal their case, which is reviewed by an appeal panel. And if the decision is upheld, a second appeal can be heard by the Professional Standards Board Executive Committee, who will then make a final decision. But in all of this, the CRC is aware that RESNA must protect ATPs from false claims as well. Now, if a complaint is determined to have no merit, it means that insufficient evidence was submitted to the CRC for them to render a decision. The complainant will be informed of this decision, and if there's additional evidence that wasn't initially submitted, they can certainly submit a new complaint with the additional information, or have others with direct knowledge of the issue submit information relative to the complaint as well. If a complaint has merit, then the PSB may send a letter of concern, which details the acts or behaviors that, if uncorrected, could lead to suspension or revocation of certification. The letter may be private, meaning it's only sent to the certificant, or it may be public, depending on the violation as well as the circumstances. If a private letter of concern is sent to the certificant and the violation is not overturned on appeal, then a public letter of concern will be shared with the certificate's employer and may be shared with legitimately interested parties, such as licensing or certification boards like NARTS, reimbursement entities, or legal authorities. If a violation warrants, then probation may be warranted for a specific length of time and for specific terms of probation in accordance with the recommendation of the CRC and or the appeals panel. It should be noted that an ATP on probation will not have their name removed from the database. Now, when an ATP certification is suspended, it too is for a specific time frame or may require specific corrective action or remedial acts to take place before certification can be reinstated. Recommendation for suspension is always reviewed by legal counsel prior to it being imposed, and the certificate's name is removed from the database because they are not in good standing with RESNA. Now, there are several ATPs who have actually had their certification revoked. Revocation is a permanent sanction, and the ATP certification cannot be reinstated. This recommendation is also reviewed by legal counsel prior to implementation. Now, there are certain situations where the CRC may review a complaint pertaining to an individual who's not an ATP. In that case, the person may be deemed ineligible and barred from becoming certified, either indefinitely or for a specific time frame. When we look back at the number of complaints reviewed by the CRC since the process was implemented in 2008, we can see that it has fluctuated quite a bit over the past 14 years. But the important takeaway here is that we have a process in place for self-policing with the good moral character affirmation, but we also have policies and procedures in place to protect the public, the certification, the profession, and the individuals. So to recap, Mike is going to look at categories of complaints that have been received over the past 14 years and that the CRC has adjudicated. What we would ask for you to do now is to think about some scenarios that you may be aware of that call to mind some of the standards of practice we have just discussed. Without submitting any identifying information, please begin submitting your scenarios in the Q&A box as Mike highlights the general categories of complaints. And while we cannot give any specific advice regarding any issue raised in the chat box, we certainly hope that this leads to some thought-provoking discussion. Mike?
Hey, thank you, Julie. The first category of complaints is false advertising, falsifying documents, or false communication. Examples of this would be a supervisor filing false experience to meet eligibility requirements, marketing or promotion materials, falsely advertising information, and then falsifying an ATP certificate. And this, a lot of these fall into the category, you just can't make this stuff up, but we've had individuals actually take certificates and copy them and put their name on them in place of the person that was actually certified, and those have been turned in for complaints. We've seen business cards where individuals claim to be an ATP and they're not, or they claim to work for us, a RESNA certified company, which there is no such thing as a RESNA certified company. And those are just some of the issues we've seen under that category. Next is misuse or misrepresentation of credentials. This could be ATP on written or oral communications, business cards and email certificates when you are no ATP, creating titles like ATP in training, certified AT specialist, signing off on another's work without seeing the client. Julie spoke of that in the standard of practice, where if you're sending someone out and then you're signing off, not communicating credentials for the specific for role of service delivery, an OT who is working as a supplier and not communicating that you're, we have seen that complaint a few times where we've had clinicians go into the home and the clients think they're a treating clinician instead of the supplier ATP who happen to be a clinician. So using your designation without earning it, designations when you're inactive, suspended, revoked, or termed, self-created titles, inappropriate, inaccurate use of designation on business cards, and then scribing, which Julie hit up on scribing, which seems to be a hot topic in the past year or so.
I'm going to jump in here real quick, Mike. Yep. So you guys may notice that there's a document that's kind of off to the side on this screen. It's the disclosure guidelines for use with your ATP. And it's a pretty good document that's included in the handouts that are available on the ISS website. That is a good read as to what's okay and not okay in terms of communicating to others, not just roles and responsibilities, which would typically be direct verbal communication, but guidelines as to how to include information in written materials. For example, if an ATP, supplier ATP, for example, were to do a technology assessment and generate a document that identifies why each component might be needed by the individual. So there's no such thing as a letter of medical necessity theoretically, right? So it's an equipment assessment and recommendation. But if the supplier ATP then hands that document to a clinician to sign off on as if it's their work, that would be inappropriate. However, if the supplier ATP were to sign and date that document as the person that generated the information, and the clinician would then concur, sign, and date the same document, that would be appropriate. So tips and tricks like that are included in the disclosure guideline document.
Thanks, Julie. We've seen state Medicaid systems utilize that, where they want the ATP assessment, but then they want the physician or clinician to sign off an agreement. So I've seen rules where it has to be on the supplier letterhead, signed first by the ATP, then second or third by the physician and clinician. So consumer generated complaints, lack of follow-up, billing for services not rendered, incorrect equipment delivered or substituted, not taking the consumer family opinions into account, recommending covered items for self-pay, and taking direct payment for consumers. And these are all, these seem to be several complaints from consumers fall under this. And then getting the documentation, the supporting documentation, so we can really investigate these. Substituted lesser equipment for what was prescribed. One of the cases, and fortunately, the consumer had copies of what was recommended by the clinician, signed off by the doctor, and then she had the EOBs from Medicare on what was billed for, and then she had copies of her delivery ticket of what she signed for, and then pictures of what she was actually delivered. A group 3 multi-power seating system was recommended. It was billed for, it was paid for, and she's in a group 2 with a captaincy is what was actually delivered to her. That may be one of the more serious ones that we've seen. Again, like Julie had mentioned, delivering a picture of the equipment and asking the consumer to sign off so it could be billed before the end of the year. Long lifetime for procurement without reasonable communication. Self-pay instead of billing insurance or offering other funding sources. Client has the right to pay for items not covered or for upgrades, but it needs to be clear, and it is best to refer back to the clinical team. I think this is an area where I think we've seen improvement, but a lot of times we don't offer the client the full recommendations and give them the financial choice of what they want and don't want. And then taking a consumer's check and cashing it for personal gain. This is one, we actually had a complaint, and we did have a canceled check that the ATP endorsed it and cashed it, and it should have been made out to the company. When the lady got a bill for the equipment, she was like, well, I paid the guy at delivery, and she had a canceled check that he endorsed and cashed it. So criminal offenses, stealing, fraud, embezzlement, felonies, alcohol or substance abuse, domestic, child or elder abuse, slander or libel, child or elder abuse reported on good moral character affirmations. Alcohol or substance abuse, we've had this come up, and like Julie said, fortunately, we've had the ability to, place that person on probation and give them recourse to go get treatment. And we've had reports of ATPs caught stealing patient medication. We've had selling stolen equipment from company for personal gain. We've seen that. Hands-on evaluation as a ruse for inappropriately touching clients. Unfortunately, that has come up. Convicted for felonies not related to AT provision. And those, we've seen some of those come up, and then embezzlement.
And recently, having some discussion with some ATPs where a competitor, and this is getting into what can or can't RESNA do, but when a ATP and a clinician has worked with a client and created a solution that's acceptable, to have somebody else, another ATP, indicate that the evaluating clinician or the supplier ATP didn't know what they were doing and just approach unsolicited a consumer and basically badmouth everything that they're sitting in or on or using, and saying, hey, if you just switch to my company, we can take care of all the problems that, you know, I'm telling you about right here. Certainly, you know, we're all in this together, and that type of activity would be considered slander or libel. Now, to date, we haven't had a single complaint filed with regard to that type of scenario, and yet there's air quote talk on the street that it's occurring on a more regular basis than we would ever hope that it would. And so again, the individuals that have direct knowledge of those types of activities can file a complaint and keep their good name, as opposed to, you know, fighting it, you know, in the trenches with no recourse.
Thanks, Julie. The next category is confidentiality, not holding client files securely. It's your responsibility, if you do have protected health information, to make sure it is maintained secure and not, you know, not leave client folders on the dash of your car where anyone can see documents. Soliciting of client business to new employer based on previous medical knowledge. Transferring clients to new employers. If you, as an ATP, quit one employer and go to another, you cannot take those client files. They're not yours. They're your employer's files. And we've seen a lot of people get in trouble for doing that. And violating privacy laws or not protecting confidential information. We have to be professional and protect the client information that we have in our possession, and not talk about someone at a party when their cousin might be there and listening to it, and it gets back to them and it upsets people when they know they're being talked about. So we have to be very cautious of that. Cheating during the certification exam. We've seen this happen. We've had lack of team cooperation is an interesting one. Lack of team cooperation. If someone's refusing to participate and just want to do it all on their own, and the consumer's being seen by a clinician, and the ATP is refusing to go in and participate, or the ATP is going to do no direct assessment, conflicts of interest, refusal to participate in assessment based on a consumer's health status, which this was one that probably 10, 12 plus years ago, we had a complaint filed by a clinician where the ATP had refused to go in and do an assessment on a client who was HIV positive. We did take action against that ATP at the time for refusing that. She was adamant that she wasn't going to go into that home or have anything to do with that person. So we took that quite seriously at the time. Cases where RESNA cannot take action are employer-employee issues, complaints against someone who is not RESNA certified or eligible, complaints against the company or organization, or other issues better addressed by accreditation standards, state licensure laws, or other authorities, such as this local state police, FBI, OID, DOJ, or other authorities. I do know in several complaints, we do refer people to contact a lot of these authorities. One thing that I think Julie kind of hit on was, if there's someone who if there's someone that is actively participating in some issues that would resolve in a complaint, but they're not a RESNA ATP, but you think they're at a company and they're wanting to get to that point, it would be a good idea to go ahead and file a complaint against them, and we could have that on record, because we could possibly look into it and they may not be eligible to set for the ATP, or we could take action and tell them what their what they're doing wrong or what they need to correct before they could sit for the exam. So 6 questions to ask when faced with an ethical decision. You know, when any of us are faced with this, we should look at this, but who are the stakeholders? Am I being balanced toward all parties involved? Do I have all the information, or am I missing something? Snap decisions are oftentimes the wrong decisions. Am I breaking any laws, violating any policies, or are there rules of the road that I need to consider? What are the short-term and long-term consequences, and can we live with them? Is my decision in line with personal core values, the core values of the company and society in general? What would my mom think about my decision, or how will this look on the news at 10? Those are all important things to consider when you're faced with an ethical decision on whether you're going to file a complaint or not. So,
or engage in activities that may result in
yeah.
a complaint being filed against
right.
you as well.
Right. Yes.
So I want to thank you guys for participating. And I know that there are a couple of things written in the chat. Dave Brienza, I've read yours. I'm not exactly sure what you're asking here. So if you could expand on that, or maybe we can unmute you to find out. But as we move along, somebody asked if we could explain scribing again. And scribing has become a hot topic recently. And scribing is, for example, in a team approach where we're all working together in the evaluation and recommendation process, which is certainly preferable. As a licensed clinician, if I take a hip range of motion and call that number out over my shoulder, and Mike writes it down on the document that is being used as the medical record, that's scribing. That is not allowed, because as the clinician that's doing the evaluation and billing for my time in that evaluation, there's a documentation component to the billing of that CPT code. In other words, not only am I required to do the documentation, but certain tests and measures like balance, range, strength, sensation, skin integrity, etc., are protected by state licensure laws and practice acts as to who can do it. So there are components to the evaluation and recommendation process that would be perfectly acceptable for the supplier to detail, either in collaboration with the clinician or on their own document where they're recording that information. But what cannot be done, and the AOTA and the APTA have both come out with statements making it very clear that in seating and wheel mobility evaluations, there are components of the evaluation that cannot be written down by the supplier ATP, who is an active participant in that process. The next one says, when consumers must wait extreme periods of time for repairs, does this help them in any way? Certainly, like we said, that's the #1 consumer complaint that RESNA gets all the time. Somebody should do something. And really the resolution of that is that there needs to be a conversation between the consumer and the company, or the supervisor of the ATP that's not being responsive. If there are miscommunications, however, if there's misrepresentation, if there's unreasonable risk as a result of it, then there may be a formal complaint that the consumer can file against the ATP. But does it boil down to a lack of communication? In other words, there are steps in place when repairing, replacing, modifying, adjusting, when additional components are going to be necessary for a consumer-owned device. And when a third-party payer is involved in that, sometimes that's where the problem lies, is getting the documentation from the physician or clinician, getting it through prior authorization with the insurance company before it can be ordered. Things that might be delayed, especially with supply chain issues. So we've seen that happen even more recently. But the bottom line is,
Julian,
if there's a
Mike?
lack of communication, that's a
Yes.
problem.
I just want to, sorry to interrupt, it is 2 o'clock. I put the CEU code into the chat. It is JNXFIM, and it is in the chat. And
If
you
anyone
guys-
wants to email Julie and I any of these questions to further have the conversation, we'll be happy to take that on, because there's a lot of information to process through on some of these.
Absolutely. And thank you all for joining. Really appreciate it. And don't hesitate to reach out and let us know what's going on. And we'll take care of it, because the only way we can take any action is if we're aware of the issues. So thank you very much for your time. Have a great day, everybody.
Thanks all. Bye.